Okay, so today I'll start with the first topic for this session. It's where you stopped at your last class. It's appointment and removal of judicial officers. So I'll try to touch on the examinable areas in your exam. Okay, so when it comes to appointment and discipline of judicial officers, you know that of course there are two phases. We have on one hand judicial officers, in that you have judges, justices, and whatnot. And of course, from the constitution, you can see the different strata of justices that we have. We have the Federal High Court, we have State High Court, we have Sharia Court, we have Constitutional Court of Appeal, and so on and so forth. And of course, it means that they have different ways of appointing and removing, although quite similar, to be fair. So I'll just give like a brief summary, and hopefully you can go back to your notes and see how to go about it. So, first of all, the appointment of these officers. We have Federal High Court of FCT and State, so they have similar requirements. So for this particular kind of court, you have to be at least 10 years post-called. Then for Court of Appeal, Constitutional Court of Appeal, you have to be like 12 years post-call, and then for Supreme Court of Nigeria, it has to be 15 years post-called. Then for the NIC, it's a bit not so different, but a bit different. Still 10 years post-call. However, they expect you to have experience in the practice of labor matters. And why? NIC usually deals with employment-related issues. So if you're going to be a judicial officer there, you must be able to, at least know how to handle those issues with practical experience on labor law. Also, we now have the Sharia Court of Appeal. They too, they have 10 years requirement. However, the other difference is that you have to have some form of qualification in Islamic law. That's if you're a legal practitioner. But because of how Islamic law is built, sometimes we also have people that are not lawyers that sit on these tribunals or on these cases. So for them, the requirements are a bit different. So if you're not a lawyer, but you are going to practice as a Qadi in these courts, you should have at least 10 or 12 year experience. In Islamic law, so that you can be able to sit on these cases. So we have similar thing in the Court of Appeal. The Constitutional Court of Appeal, wherein you should also have, if you're a lawyer, you should have 10 years post-call experience, but with an experience in customary law practice. So if you're still in Igbo land, you should have an idea of how to solve customary issues. You should know how, for example, how they share properties, how they divorce, basically customary issues, how they do land sharing. And if you're not a law practitioner, you must at least have those experiences in that area. That people must know that you have that experience. So with that said, do you understand what I've said on how to, maybe the qualification for you to hold these offices? Do you understand? Do you understand? Yes. So as a run through again, for literally most of these courts, except Court of Appeal and Supreme Court, you have at least 10 years experience. The only difference comes in Sharia Court of Appeal and Constitutional Court of Appeal, wherein if you're not a lawyer, you have to have, if it's for Sharia part, you must have at least 10 years or such qualification in Islamic law. But if it's for Constitutional Court of Appeal, you must also have experience. So can somebody tell me, okay, let me ask, I will list some courts and you tell me the year of experience that you require. So if you're going to be a judge in, let's say, Federal High Court, High Court of State, or FCT, how many years post-court experience must you have? Say it with confidence. How many years experience do you need?
10 years.
Yes, thank you. So if it's not NIC, how many experience do you also need?
10 years, but with experience with labor matters.
Wonderful. So Feyi, don't say anything for now. Temtayo and Dame, these questions are for you. If you are going to be a caddy in a Sharia court of appeal, whether it's in the FCT or in the state, what experience do you want to have? Will you have?
You said that they should be Islamic laws.
I said what?
They should be learned in Islamic law too.
Okay. So I mentioned that for this kind of qualification is in two phases. Whether either you're a lawyer or you're a non-lawyer. So give me the answers in both of those instances. So if you're a lawyer, how many years post-call experience and what do you need?
For which court?
For the Sharia Court of Appeal.
It's 10 years.
Okay.
With, experience in and knowledge in Sharia law.
Yeah, Islamic law. So what if you're not a lawyer?
Lawyer is not the same thing.
No, they are not the same. You can either be a lawyer or a non-lawyer to sit on Sharia matters. So you've already answered for if you're a lawyer. You have at least 10 years experience. What if you're not a lawyer?
We have experience in Islamic law only now.
Like how many years?
10 years.
So you have Islamic qualification for at least 10 to 12 years respectively, whether it's for the Curriculum Appeal or FCT. So I want you to know this. There are of these differences. Okay, so Temitayo, the last question is for you. If you're going to sit on a panel of Curriculum Appeal, customer Curriculum Appeal, what qualification do you need? Temitayo, are you here? Okay. Can any other person answer this question?
For legal practitioner, 10 years.
Yes.
And also experience and knowledge with for non-legal practitioners, 10 to 12 years experience in customary law.
So, okay, that's correct. But however, for customary court of appeal issues, I'm not sure the constitution especially writes 10 years, but you can confirm that in your notes. But I'm starting for the one for Islamic matters. Anyway, that's just to give you an idea. So, lastly, can you tell me how many experience you need to be a justice in court of appeal?
12 years.
Yes, and in Supreme Court?
15 years.
Perfect. So that's basically it. So another question that I may ask you in your exam is, what's the procedure to appoint? So I'll give you a run through. I don't expect you to memorize it right now, but I just want you to understand that procedure. So when you go back to your notes,
can I try?
Oh yeah, okay, that's perfect. Yeah, you can try.
Okay. See by the National Judicial Council. I don't say you for Supreme Court is the President on recommendation by National Judicial Council.
Okay.
And subject to approval by the Senate.
That's good. It shows that you have an idea of it, and that's very good, because in your exam, that's one of the things that are very important. So when they do ask you, those are things that you should have in mind. So just run through it and know that you people can learn it from this class so that you can memorize it. So first of all, for the process of appointment includes notice of intention to appoint a specific number of justices or judges, and it is sent to the chairman of state judicial council and the governor. However, if it's for FCT, they send it to the Judicial Service Commission of the FCT or head of federal government and then it goes to CJN or chairman of NJC or chairman of Federal Judicial Commission, depending on which court. So I'm just giving a combination of all. I'll start again. First thing first is to send a notice of intention to appoint specific number of the judges. Just know which one is applicable to each court. But the first thing is to send notice of intention. The next thing is call for expression of interest. from and the nomination of suitable candidates. So they will bring that call if you are interested and you see that you have that qualification, then you can now show your intention. The next thing is the making and circulation of a professional shortlist of candidates, and then request for comments. So this comment is to know if people agree with those things that person is claiming to have, or if person is in the right standing they typically. So again, just so that you can know, I'll mention 3 steps. First of all, notice of intention to appoint a specific number of justices is sent by, depending on where it is, if it's High Court of a state, it's going to be sent by the chairman of the State Judicial Service Commission and the governor. Then if it's for Act of FCT, it is sent by the chairman of where? The chairmancy of FCT. Then or if it's of head of Federal High Court, then to send it to CJN. But if it's Federal High Court, who will send it also? Chairman of where? Federal Judicial Service Council. Or you get, so that's know which person per court, but not that across board they will all send a notice of intention to appoint a specific number of judicial officers. The next is the call for expression of interest from, and then they will request for nomination of suitable candidates. So again, notice of intention, next call for expression of interest, and the third, making and circulation of professional shortlist of candidates.
So I did not hear the second part.
Call for expression of interest from.
It's an expression of
interest, yes, and then request for nomination of suitable candidates. So did we get that part? Did we get that bit?
Yeah.
Okay. So the third one is they will make and circulate a professional shortlist of candidates and then request for comment. So when they send that initial form for people to express their interest and request for nomination, from that abundance of list to make a short list, and then that will circulate for people to give commentaries. Then the fourth step is that they will now place that short list for approval. That professional shortlist for approval. So did we get that 4 first steps? Did we get the 4 first steps? Did you get the 4 ahead?
So the first one is notice of intention.
Yes.
To appoint a certain number.
Yes.
Then call for expression of interest.
Yes.
Request for nomination of suitable candidates.
Yes.
Then we said they will make us circulate the shortlist.
Yes, record that shortlist, a provisional shortlist. Yes. And then request for comments.
Then place shortlist for approval.
Yes, so that's the first 4 steps. Then the next step is that they will now send what they call a NJC Form A to those shortlisted candidates for them to fill and return with specific attachments. Then after that one, they would table a memorandum on each shortlisted candidate for consideration with some documents, and afterwards they will decide on which candidates to recommend to NJC. So after the next 3 steps, they will send them a NJC Form A to the shortlisted candidates for them to fill and send back with some attachments. Then afterwards they will table it in a memorandum to see who they would shortlist, who they will shortlist for consideration. Then the next thing that will not decide on the candidates to recommend to NJC. Do we get that part? Do we get that part? Okay. So I'll proceed. Then after they decide on who to recommend to NJC, they will now recommend that those listed people in a memorandum. Afterwards, they will place that memorandum on the agenda for the next NJC meeting. Then they will now conduct an interview with the shortlisted candidates, and after, if for good that are successful in that interview, they will now recommend them for appointment to the governor or president, depending on which of the courts and finally they appoint and notify everybody that they've appointed. So do we get to that extent now? That's usually the procedure to appoint a judicial officer. So let's try. Can you list two? I think that's a total of about 12 steps. So can we try to list two of these procedures as you understand? Or in fact, just run through as you understand whether I make a mistake or not. So let's just try. Who's going first? Who's going first? Who's going first? Dim, Temitayo Fei.
Okay, let me just try.
Yes.
Notice of intention to appoint.
Yes.
Certain number of candidates.
Yes.
Then they'll call for expression of interest.
Yes.
So they will make a request for nomination of suitable candidate.
Yes.
Then they will make and circulate a shortlist, a provisional shortlist from the nomination.
Yes.
Then they will place that shortlist for approval.
Yes.
And send a form
yes.
to the candidates for them to fill.
Yes.
And
okay.
Say something about table memorandum.
Yes.
And then they will decide on which candidates to recommend.
To where?
To NJC.
Correct.
Then I got lost at that.
Don't worry, just continue as you remember, I will correct it.
Just that they will place something in one memorandum.
Yes.
And then they will now, NJC will now recommend.
Yeah, so in that part, they would recommend those people to NJC via a memorandum. And then they will now place that memorandum in the agenda for NJC meeting, for their next meeting. So I think that's the part you got lost.
Okay.
Yes, so can you
agenda.
Yes. So what's next? You're almost done.
Then NJC would appoint. Will recommend the president to appoint.
Yeah, I think so the missing step now is that they will now conduct an interview. After that interview, the people are not successful will now be recommended by the NJC to the governor, the president, and they now appoint. So that's basically it. Well done, Faye. So I hope this is a very good run through for you. So if you just go and read that, it just gets cemented. So typically, there's on one hand to appoint judicial officers. However, even in appointing them, they are not far away from making mistakes, from being found of misconduct. So who punishes them? Generally, okay, let me just leave it up for there. Who punishes these people?
Is it the legal practitioners, disciplinary?
No. For judicial officers.
For judicial.
Yes. The answer is in the procedure.
Is it NJC?
Correct, it's NJC. So when you think of judicial officers, so in fact, let me just mention in your exam, very careful too, because they might say which body is responsible for punishment. Be sure to check that they wrote judicial officers first before answering, because if you put LPDC for judicial officers, you'll be wrong, and you put NJC for legal practitioners, you'll be wrong. So just know which one. So for judicial officers, it's the NJC. And on what grounds can they be liable? Typically, the grounds are not a lot. They're like 4. It can be for misconduct. It can be for breach of code of conduct. It can be for inability to discharge their duties, maybe due to infirmity of their mind or their bodies, or because they've attained age of retirement. So again, misconduct, breach of code of conduct, inability to perform their function due to infirmity of the mind or of the body, or when they attain retirement. So there are just 4 grounds. Can we say together the 4 grounds? Number one, misconduct. Number 2, breach of code of conduct. Number 3, inability to discharge functions due to infirmity of the mind or body. And number 4, retirement. You know the retirement age now, usually like 70. Exactly. So, but just confirm it did not change, but of course, know that the general age is 70. But just confirm, just to be sure.
I saw in the constitution that for court of appeal is, I think,
65.
65.
So
court of appeal rule, someone said court of appeal rule of 2013 has 70 or so.
So that's what I want you to just confirm. So that's basically it. Thank you. So what judicial actions or different actions can you make on them? Number 1, you can warn them. Number 2, you can suspend them. Number 3, you can compulse retirement on them. And number 4, you can recommend them for dismissal from office. So again, you can warn them, you can suspend them, you can compulsorily retire them, that's compulsory retirement, and finally you can recommend them for dismissal from the NJC. So can we try to tell me 4 grounds for disciplining a judicial officer, and then the 4 punishment you can met on them? Yeah, let's try.
For the ground.
Yes.
Conduct. Breach of code of conduct.
Yes.
Inability to perform function due to
yes.
infirmity of the mind or body.
Yes.
The retirement.
Perfect. So what about the disciplinary actions?
You can warn them.
Yes.
You can recommend from dismissal from NDC, suspend, and compulsorily retire them.
Yes. So when it comes to if you have a situation where you recommended a judicial officer for dismissal, there's also a procedure for that. Yes, you cannot just if they're not expressly removed, you can just remove them. That's what I mean. So of course it's governed by the constitution. It's in section 292. But I don't want to bore you with sections. That's why I'm not mentioning sections. So judicial officer cannot be removed before retirement except permitted by constitution, and that way it must go by this procedure. How? First of all, a complaint is to be sent to NJC by the CJN.
Compulsory retirement or for recommendation of dismissal.
Yes. So what I'm talking about now is for where you want to dismiss them.
Okay.
Yes. So it is an allegation against them. In fact, it goes for both ways. If you want to dismiss them, because you know that I told you that you could, yes, even if it's compulsory retirement, those are the punishment they will not give them. But for them to be able to give them that punishment, there's a procedure. That procedure is that you first send a complaint to NJC. Yes. So then NJC will now set up a committee to investigate the allegation. So maybe you accuse the officer of fraud, of bribery, whatever the case might be. The NJC will set up a panel to be sure that this allegation you are making against that officer is true or if it is false. So you know that when they say you are punishing somebody, there must be fair hearing typically. So what the agency now do is that person that is being alleged, that's the judicial officer, be it the justice of a court of a state, anywhere it might be, will now be notified that yes, so my guy, there's been an allegation against you. Come and respond to it. And you get come and respond to it. So they will now give you reasonable time to react to that allegation that they've given against you. So if in that response they see that the allegation is proved against you, NJC can now give you the appropriate judicial disciplinary action, be it warning, be it suspension, be it compulsory retirement, be it a commission for dismissal from office. And but if of course they find allegation is false, you know that it ends there. Do you get? It ends there. But if of course if it's put against you, then they will now take those disciplinary action against you. Then if the action that NJC recommends for you is to remove you from office, then the NJC will tell it to the governor or president, who will now officially remove you from office. Where the judicial officer in question is maybe a CJN or head of court, it also requires 2/3 majority vote of either the House of Assembly or the Senate, depending on which person is involved. So to this extent, do we understand?
Yes, kind of.
Okay, so you're saying kind of. What don't you understand?
It's not that I don't understand. I just need to know all the procedures.
Okay, but let's just try. From what I've explained, to an extent, can you just flow again?
I think you said you'll bring the allegation, like notice of the allegation to the
to the NJC. No, like from the beginning, when from the complaint stage.
That's why I didn't.
Okay, so first of all, there will be an issuance of a complaint to the NJC. Then NJC will now set up a committee to investigate. Then the person involved will be notified so that he can come and answer to the allegation in a reasonable time. If they find him liable, then the next step is to give him punishment. If he's not found liable, it ends there. Where the punishment they want to give him is to remove him or dismiss him. The governor or president, depending on the case, is involved, so they can remove him. But where is now the head of that court, maybe it's a CJN or a CJ, they will now also need, in addition to just the governor or president, they will also need at least 2/3 majority votes of either the House of Assembly or the Senate, depending on which of the person is involved. So do you understand it? Do you understand to that extent?
Yes.
So can you just try to just repeat it?
So you said the issuance of complaints
Okay.
to the NJC.
Yes.
Then NJC will set up a committee to investigate the allegation.
Yes.
Then they will notify the judicial officer of the allegation and give him a reasonable time to react to the allegation.
Yes.
Then if he's found guilty and the punishment is dismissal from NJC,
Yes.
NJC will recommend to either the president or the governor, depending on what what court is a judge.
Yes.
And then instead there's additional vote of 2/3 majority or either the House of Assembly or
Yes.
Senate.
Yes.
And then they will now recommend to the president and governor to remove.
Okay. Yes, so you are correct. That's typically how to remove them. So you are correct. So now we've now dealt with judicial officers. We'll now go into legal practitioners. So what do we do where the person involved is not a judicial officer but is a lawyer? Me and you now, if we offend, how do they punish us? Who is even in charge?
LPDC.
Yes. So in addition to the LPDC, we also have the Supreme Court or the CJN.
Yes.
Yes. I don't know if people heard of a recent case where a lawyer was told to pay a particular fee.
Yes.
So you can see that it's not just LPDC. LPDC is like the major body, but they're not the only one. So we can find this in the Legal Professionals Act. So for example, LPDC is section 11. Supreme Court is section 13.1, and then CJN is section 13.2. Yeah, so that's just basically the people that are involved. So what punishment?
I think there's a limitation to
Yes.
CGN.
Okay.
I don't know, I'm just asking.
Well, of course, all of them have the place they can function in, but generally speaking, the bodies involved are just three. They're just three: LPDC, Supreme Court, and the CJN. So they are a bit more defined when you look at their scope. Are a bit more defined when you look at the Legal Professionals Act. I don't know if you have that. So let me open it and just read the section out for us. But we can just proceed. But if you have it, you can read it out for us, so that we can just, I can basically delete it in today's class. So, but going forward, okay. But you can check your Google. You can. Let me check from my end if I'm able to open it. Okay. So either way, even if you can't see it today, we can always discuss it on the group chat. I'm trying to see if I can open it from my end anyway, but let me see if I can open it. Section. Okay, so this one is kind of abridged anyway. But under section 13.2, it says that the CJN can independently suspend an erring lawyer from practice for a specified period if it appears to protect the integrity of the profession pending further inquiry by the LPDC. So I get that as limitation. So do you get that bit? I
don't know if you can explain it.
Okay. So I'm saying that for the CJN, I don't have the section, but an aware person is saying that the CJN has powers to punish a lawyer pending investigation by the LPDC. So for
they can suspend.
Yes, they can punish you temporarily if it's very necessary to protect to protect the profession. And they can easily do that ahead of that time. So that's where they operate. So, but generally speaking, usually I'm coming. Sorry. I'm the message. I'm coming. Sorry. Okay. So I'll just proceed. Sorry, I had to respond to one of the facilitators. Going forward, what are the offenses? So, unlike for jobs, as I said that the ground for their own dismissal or discipline is usually made. It is a misconduct, a breach of code of conduct, inability to discharge functions, development of the mind, of the body, or attempt of retirement. For lawyers, it's quite similar but not the same. Now, what are the offenses a lawyer can commit? Number one, for judges, I mentioned misconduct, but for lawyers, the difference is that their own is infamous conduct. And I'm only saying it side by side because I want you to be able to understand the difference if you're asked in your exam. because sometimes many of us used to mix them up. We used to mix them up. Okay. Sorry. Okay. So I'll just proceed. Infamous conduct in professional respect. So where a lawyer is said to have maybe seriously infracted. Sorry, I'm responding to somebody. That's why I'm pausing. Sorry. When a lawyer is being accused of seriously infracting a standard of profession, maybe by his acts or by how he did it, maybe however he does, then you can punish him or you can make an allegation against him under infamous conduct. So I think a popular scenario might be, maybe say a lawyer is found to, maybe, let me look for a good example. Maybe he was even maybe he said he committed armed robbery, for example. Now I don't know.
That one is under
conviction. Yes, I'm not doing a good example.
Okay, maybe let's think about section 57. I said section 57. Rule 57 of RPC, that if you don't comply with the obligation to report on anti-money laundering.
Because some of these examples are quite similar because of their where they fall under.
That's what I'm saying.
Yes, so but I'm
saying that if they don't report money laundering, then they are guilty of professional misconduct.
Okay. Yes. So most times, exactly. That's a very good example. Another one, maybe where they appropriate or convert a client's money, for example. You're not supposed to be doing that as a lawyer. So that's infamous conduct. Or maybe you withhold a client's fund. Or another example is if you are found to abuse court process, because some lawyers can be going from, they can institute a motion in this court because the court doesn't grant it, they go to another court, bring the same motion, that doesn't grant it, go to another court. They kind of forum shopping. If you are found that kind of conduct, they can actually bring this kind of offense against you. Maybe you even bribe the chief officer, and I think like Faye mentioned, where you are found mostly to have breached the RPC. These are examples of where you can be. These are offenses that they can say that okay, you have breached a conduct in professional respect. Example again, breaching of client confidentiality, conflict of interest, and so on and so forth. So the next offense. Okay, let me give you a case. A case that you can use in your exam is maybe MBA and Mabawonku. Is a local class case that people used to use.
Can you spell that?
Mabawonku. Other cases, MDPT and Okonkwo. That one it's a medical professional case, but because you know that lawyers are medical professionals in their own respect, just use that case to just tell you the areas, because you know that in that case now the particular medical professional that was found to have done something that was wrong to the medical profession, and then they now punish him accordingly. So for lawyers too, in our profession, if you are found to have done that kind of thing, they'll punish you. So those cases are local practical cases on this example. Another offense that a lawyer can also be said to have breached would be when they say that you are being convicted by a court for an offense that is incompatible with your status. So if you are convicted for armed robbery, for example, you already know what this is. And so on and so forth. So if a lawyer commits an offense that's incompatible with his lawyer profession now, that is disgraceful to us, you can say that kind of thing against him. So, or maybe where the lawyer is and when they bring that allegation against the lawyer in court, and the court now convicts him of that allegation, you can now bring particular ground against him. Another example is when he obtains the enrollment by fraud. This is very popular. An instance where you use forged documents or fake identities to get caught to bar, and then you are now caught. You know what this means now? Because in the first place, you're not supposed to be a lawyer. So maybe you know, in law school, you have your better measures form. They will ask you that have you been convicted before? Maybe they've even charged you for kidnapping. Then you're not supposed to know. Then later on in your year of practice, they discover that you were even lying. So of course they can bring this thing against you because you're not supposed to be enrolled in the first place. So you can say, no, listen, they look similar, but they're not the same. So your exam, be very careful of the kind of example that I'm presented to you. So if you see an example where they say the lawyer wants to is going to be dismissed because of enrollment issues, know that they're talking about this particular ground. If they say that you have been convicted, bring on this ground. But if you're not convicted, you cannot come to the fourth ground, which is conduct incompatible with the status. So any infamous conduct that can break this able to legal profession where you have not been convicted can easily fall under this ground. But if you've been convicted by a court already, is the earlier ground. So these are the four main ways. I can call it.
But I didn't catch the fourth one.
Yes, I want to even give you an easy way to remember. I'll call it the ICOC acronym. So the last C was where I said where a lawyer is found to have committed a conduct that's incompatible with his status as a legal professional. This
What's
ground.
the second conduct?
The second one is conviction by a court for an offense. So they are kind of similar, but in one case they convicted you, in the other one you've not been convicted. That's I said that they're very similar, but they're not the same.
Wait, please call that second one again.
I think from beginning. So I said they are ICOC principle. ICOC. First one is infamous conduct in professional respect, where I said if you flaunt the rules of RPC, you know where you fall in. Maybe breach of confidentiality and so on and so forth. And I mentioned the case of MB and Baba Uncle. Second instance is where you are convicted by a court for an offense incompatible with your status as a lawyer. Third is where you are obtaining your enrollment to the Nigerian bar by fraud. Maybe where you bring false identity, false certifications. Maybe your mentions form, they had asked you if you were convicted, but you did not mention it at the time, and that found in practice. They can also bring. Because that means it means that if they are found before you call to bar, they will not have given you that. They will not call you to bar, so they can take you out. And then finally, where you are found of a conduct that is incompatible with yourself as a lawyer, this is the fourth ground. So do you understand? Isn't that acronym? So the first one again is what? Infamous conduct in professional respect. The examples of that is what is you see many of that in the RPC. And I think you mentioned an example of 57, so you can think of that. Another one is the C, conviction by a court in Nigeria for offences incompatible with your status. So it can be, it's a lot of offences. It can be robbery, it can be anything, but you're convicted. And then the court tries you, then the court now convicts you. So don't forget that these elements must be there. There's an offense, that lawyer is tried and is convicted by a court. The O is obtainment of enrollment by fraud. So when they find this, you already know what will happen to you in that case. Then last one is conduct. Conduct. So when they find you of having conducted any offense at all that is, that can bring dishonor to profession. Use this example. So why I'm saying this on my own, because in your exam They can frame this thing in any way. But if you know which element will be present in either case, you will know which ground to add. So let me now try and give you a trick question, and I want people to answer me. Anybody at all can answer. So let me put an example where let me look at where Ewaoluwa is found to have been involved in armed robbery as a lawyer. What ground of offense will you bring against her? But rebut against her? Where Ewaoluwa, a legal practitioner in Lagos, committed armed robbery, what ground of offense is most suitable for her?
Conviction by a court to an offense, that's if she has been convicted, or conduct incompatible with her status.
Again, now we ask the question. Don't assume. Answer the question as I'm asking you, because if you write on your exam, you're probably going to fail it. So again, try again. Ewaoluwa, legal practitioner. Yes.
Okay, then conduct incompatible with
Exactly. So now I don't know if you're not getting the trick I'm trying to bring out. In your exam, they can bring it this way. But if you are thinking that if you assume what's not in the question, you will answer what's not in the question. So that's what can now affect your score. So just this job me try to say that you should pay attention. So let me give another example. Where Ewaoluwa, a SAN, is found to have converted Faye, a client of 10 years, money. What kind of offense will you give against her? Don't mix the ground for judicial officers with one for lawyers. Again, lawyers' own is the ICOC principle. I will take a question again. Where Ewaoluwa, a SAN, was found to have converted Faye, a client of 10 years, money.
Okay.
What kind of
conduct?
Exactly. Exactly. If you not like self to show that to show that you know too much, you can even put the applicable RPC that she breached if you want.
That's Rule 23.
You get show that if you like, or if that's if time allows you. Okay, so where Ewa is said to, Ewa is an SAN, but when Ewa was in law school, Ewa was convicted of armed robbery. But in her bond lectures form, she had put that she was not convicted. But now, as a SAN, that detail was found out. What is the suitable offense?
Obtaining enrollment by fraud.
Good. Now, Ewa and Faye are friends. Both of them are legal practitioners. On one hand, Ewa was said to have divulged client details, and also Ewa was convicted for fraud. Then Faye, on the other hand, had given fake identities before she was caught, and also Faye was found liable for stealing. Give the offenses.
However, the must conduct in a professional respect.
Why?
Because she breached Rule 19 of RPC.
What was her offense in that respect? Good. Next.
Conviction by court for an offense incompatible with that.
Yes, good.
Therefore, obtaining enrollment by fraud.
Good. Why?
And conviction because she used fake ID.
Good. Good. So I think you understand. Stephanie, do you just understand? I notice you've been quiet. Okay, that's good. So typically that's just the ground. So I want to now ask that question. Give me the 4 grounds that a lawyer can be punished for, and the 4 grounds that a judicial officer can be punished for.
Judicial officers misconduct.
Yes.
Breach of code of conduct.
Yes.
Inability to perform function.
Yes.
Retirement.
Good. So this one you can call it the MIBA principles. I like acronyms. Sometimes you have to remember. Maybe if we are doing revision later on, I'll give people a bunch of acronyms because it helps you in remembering always and help not to get confused. Thank you.
MIBA.
Yes. So that's M for misconduct.
There's no N.
There's I. MIBA. M for misconduct. I for inability to discharge. Yes. B for breach of code of conduct. And A for attainment of age of retirement. So you understand what I mean now by MIBA?
Okay.
Yes. Then for your other one, what's the offenses or the grounds?
We have SUC.
Yes.
Famous conduct in a professional respect.
Yes.
Conviction by court for an offense incompatible with status. Obtaining enrollment by fraud.
Yes.
And conduct incompatible with status.
Good. So let me just give you a case for conviction. You can use Sage and the Queen. SAGOA and the Queen. Versus the Queen. So okay, we're going to get to the end of this topic. Procedure for enforcement. Usually for lawyers, they usually bring an application, unlike judicial officers where they will bring a complaint to the CJ and to the NJC. Sorry, for a lawyer, they use an originating application. So you take that you send it to either the CJN, the AG, the President of Court of Appeal, presiding judge of the Court of Appeal, to the LPDC, to Chairman of the Board of Benchers, President of NBA, anybody you like, just send it to them. Then that the person that receives it, whether it's a CJN or anybody at all, that receives that written application, will now send it to the LPDC. You get? Then the same procedure again. They will consider whether it's true or false by the ICM. They call them initial committee members, and then they will now check whether there is truly a case to answer or otherwise. But of course, they might bring you to also talk because they want to show that you have fair hearing too. But anyway, let me just come back to what I was saying. Again, the first step is through an originating application sent to either the CJN, LPC directly, Chairman of Board of Benchers, MBA, anybody you can send it to will now then, the second step now, will now send it to the LPDC. The third step is that application that you now send will now first of all be considered by the initial committee members, in bracket ICM, initial committee members. Where there is a case to answer, we will proceed. But where there is no case, at that stage they will dismiss the application. So now, where there is a case to answer, the secretary of LPDC will now serve a copy on the lawyer that's the correct person in that case, the respondent. They will serve that copy of that thing on the lawyer, aka respondent. Then they will now fix a date for hearing. They will give the person notice to come out, so that when they not come for hearing, you know how normal court procedure now. They will hear your application, submit addresses, reporters, and all kind of stuff. So you are also allowed to submit final written address to LPDC. Then after that hearing, the LPDC will now give direction whether they don't to dismiss you or want to punish you. That direction that the LPDC now gives will now be gazetted. I'll take it again. First of all, unlike JO, that's judicial officers, where they come by complaint, for a legal practitioner, the step is that they bring an originating application which they send to anybody. Anybody is not anybody. The anybody can be is either the chairman of the CJN, chairman of MBA, president of Court of Appeal, In fact, there are many of them. Or you send directly to the LPDC. So where you had sent it through any of those people, that's CGN, Court of Appeal, those heads of court or end of MBA, those persons will now send it to LPDC. So you can get that there are two instances, either directly or indirectly. But either ways, that purposes what you sent in uniform is what? Originating application. That originating application will now be considered first by the initial committee members. Where there is a case to answer, you will go to the next step. But when there is no case to answer, that panel will dismiss the application. So, but are we together? Okay. So, when there is no case to answer, they will dismiss it, the application. But when there is case to answer, the secretary of LPDC will now send a copy to that lawyer that is involved, aka the respondent. Then the assistant secretary will now fix a date for hearing and serve a notice on the legal person in charge or other parties involved. Afterwards, they will now hear that complaint, in brackets the originating application. So the person involved is allowed to comment, the usual process. In fact, is allowed to bring a final written address to the LPDC. After deciding on that issue, the LPDC now said, okay, we've heard you, this is our direction. The direction can either be to dismiss you, to discharge you, to punish you. What the case may be, that direction is now what gazetted. Now, for the last time, I'll repeat the procedure. First of all, you come by way of originating application, which you can send to either the CJN, chairman body of benchers, chairman of MBA, panel of court of appeal, or the LPDC, depending on which person is the head of court in that place. Afterwards, those persons will now refer the application to the LPDC. But where it was brought to the LPDC directly, this step is not there. Thirdly, that application is now considered by the initial committee members. Where there is no case to answer, the panel dismisses the application. Where there is a case to answer, the secretary of LPDC serves a copy of a document on the respondent. Further, as on that step, the secretary of LPDC fixes a date for hearing and also serves a notice on the lawyer involved and other parties that are involved. Next to that, there's a hearing of the application / complaint. The next is that lawyer is also allowed to submit a final written address to the LPDC, basically a hearing. And finally, almost finally, the LPDC now gives a direction. Whether they want to dismiss the complaint, say, oh, there's no grounds, or it's discharged, or want to punish the lawyer. And then finally, that direction, whether to dismiss the complaint, to punish you, is gazetted. Do we understand the procedure?
Yes.
Can you breeze through it?
Okay, so originating application to either LPDC,
Yes.
AG, Chief Justice of Nigeria, Chairman of UB,
Yes.
President of Court of Appeal.
Yes.
But if it's directly to LPDC, there's no second step
Yes.
to take it to them. But if it's with any of the other people, then they'll forward it to LPDC.
Yes.
So initial committee members will the application.
Yes.
There's a case to answer.
Yes.
And when there's a case to answer, it will proceed. But when there's no case to answer, it will be dismissed.
Yes.
And Secretary of LPDC will serve the respondent
Yes.
with the originating application.
Yes.
Okay, so they will now fix a date for hearing
Who's gonna do that?
and serve notice. He's still the secretary.
Correct. Continue.
And serve notice to be responded.
Yes.
Then during the hearing, the legal patronal is entitled to file written address.
Yes.
And then afterwards, direction by LPDC on whether
Yes.
to punish. And then the last step is that whatever direction is given will be gazetted.
Correct. Well done. So that's typical procedure. So I'll now go straight to the punishment. You can call this SOSA. So sorry, I have a lot of acronyms in my mind because of that. Anyway, the first S is to strike off the lawyer's name from the role of legal practitioner by the chief registrar. The O is to, if it's maybe where they said that he had stolen money, or anyway, you order the lawyer to refund money or hand over documents in his possession. Maybe where is his maybe to a client. The next S is to suspend the lawyer from practicing for a specified period of time. Then finally, the A is to admonish or caution the lawyer. So again, SOSA, first S, strike off the lawyer's name from roles of legal practitioner that's kept by chief registrar, or order the lawyer to refund the money or hand over documents in his possession. S, suspend the lawyer from practicing law for a specified period. And finally, admonish or caution the lawyer. So that's typically the punishment. But now I want to ask this question: can you appeal what kind of things brought against you?
Yes.
Yes. So you can appeal from the LPDC to Supreme Court.
Directly to the Supreme Court.
Yes. But you must file not later than 28 days from the date that decision is served.
Decision.
Yes, that's the way. So when you are punished, you can appeal. Where you appeal, or where the case might be, maybe they've already struck your name out. How can they bring you back on board? It's also true on application that you made. You can make it to the Supreme Court or to the LPDC. What are the conditions? It's under, you can see this under section 14, section 1 of the Legal Practitioners Act, or the case of Ewaoluwa, RE space ABUAH, Ewaoluwa, RE space ABUAH. What are the ground? What are the conditions for them to bring your name back? There are 3 conditions. Where the gravity of the offense that necessitates them striking you or suspending you is not as much, they can bring you back. Or next ground, where there is sufficient evidence of genuine remorse by that applicant in between that period of suspension or striking off, they can bring you back. And finally, where the applicant in those intervening years has become fit and proper to be brought back as a member of legal profession, they can bring you back. So those are the 3 grounds in which they can bring you back. Do you understand?
Yes.
Okay. So before I take a commercial break, I mean few minutes, I'm gonna give you a few minutes of break because I know I've had a stretch. I will end by saying for this topic. So don't leave the call. You can have a break, but let me just end this topic by saying
My phone is about to die.
oh, okay, maybe maybe what I just do is that I would probably make a recording of the next class. It is arbitration,
Okay.
so that at least you will not miss it. And I mean that I just share that so that you will not miss. So let me just end this topic by saying that whether you're a lawyer or you're not a lawyer, maybe you are a justice, you are not escaping punishment. So the bodies involved, actually as I already given you examples, but you can say that where is for Supreme Court usually have original jurisdiction over lawyers in professional misconduct, and CJN also has original jurisdiction. Anyway, so I think that brings us to the end. So I'll just give you a run through of the outline of what I taught today. So today, under this topic of appointment of the discipline of judicial officers, I have taught you how they can be appointed by taking you through the court chapters, the years of everything that you need to be called. I've given you the process for appointment. I have also taken you through the discipline of judicial officers by taking you to the body involved, NJC, the grounds, misconduct, code of conduct, inability to discharge functions to the infirmity of mind or the body, attainment of age of retirement. Then I took you to the disciplinary actions: warning, suspension, compulsory retirement, recommendation for dismissal from office. I also took you to the procedure for discipline of a judicial officer, and I said that it's not automatic for it to be a judicial officer. There's a procedure. So the procedure usually form a complaint to the NJC, and NJC set up a committee that investigates. The person that's involved, that judicial officer, is notified, and is given time to react to the allegation. If the allegation is proved against him, they will take the necessary actions. If he is not, of course, that complaint is dismissed. Where they recommend it for dismissal, the governor or the president has to remove that person. But where that judicial officer involved is the head, maybe a CJ or a chief justice, then that means, in addition to the president removing him or president, or whatever the case might be, you also need to third majority vote of either House of Assembly or the Senate. Then I mentioned that that's the end for judicial officers. But of course, we know that we do not only have judicial officers in the legal profession. We also have lawyers. So lawyers can also be punished where they are found for misconduct. And in fact, RPC Section 1 is very emphatic on the fact that lawyers should not be found for misconduct. I mean, you get. And then I listed the bodies. I said we have LPDC, we have Supreme Court, we have CJN. I gave the ground of offenses that they can bring against a lawyer. I gave you an acronym. I said ICOC, that's infamous conduct in professional respect, conviction by court in Nigeria for offense incompatible with state of a lawyer, appointment of arraignment by fraud, and finally conduct incompatible with a state of a lawyer. I gave examples on this, so if you have questions, please do ask. And finally, I took you to the procedure for that. For a lawyer, I said that it's through an written application, and I gave you the outline of the procedure. Also, we have the punishment. SOSA, strike off his name from the roll of lawyers by the chief registrar, order the lawyer to refund the money or hand over documents in possession. Next is suspend the lawyer from practicing law for a specified period. Finally, admonition or question of the lawyer. And I said that, okay, even if they punish you otherwise, you can appeal. If you're not satisfied with the decision, you can appeal. You can appeal from where? From LPDC to Supreme Court directly. However, there's a clause within 28 days of when that decision is served upon you. Also, whatever the case may be, you can, where you have been punished, you can apply for your name to be restored, or where you want your suspension to be cancelled. You can also apply to either Supreme Court or the LPDC. And I gave 4 conditions. I said, number 1, the gravity of offense necessitating your striking off or suspension. Secondly, I said, where there is sufficient evidence of remorse, genuine remorse by the applicant for a specified period between that striking off or suspension, they can bring your name back. And finally, where that applicant has now shown that he's become fit and proper, they can also bring him back. And lastly, I mentioned the fact that the Supreme Court has original jurisdiction for a lawyer and CJN has it. So I think this brings us to the end of this particular topic. So I hope this is very understandable for all of us. I hope it's understandable. Yes, so I think we can call it a night here. But I know that I've not given you time for questions. So if you have questions, please tell me. Even if it's my DM on the group chat, or any way you want to, maybe on our next class. But if you have questions, maybe when you read. But beyond that, do you have any questions? Let me just say that as we close. Do you have any questions?
No, I think it was straightforward.
Okay, that's good. How about Stephanie? Do you have any questions? Okay, I guess there's no question. So I think we can call it a night. Thank you very much for attending today's class.